Good afternoon, ladies and gentlemen of the media and other visiting friends. Today, Chief Justice Brian Sykes, in giving judgment in relation to a suit brought by the People's National Party, struck down the MIDS legislation in its entirety. I want to begin by quoting a statement made by Chief Justice Brian Sykes at the beginning of his judgment, where he quoted Dias Dexter, QC, from an article entitled Silence of the Laws, Dissent and Democracy in Cases That Changed Our Lives. And I quote, "Dissent has a troubled history. The word dissident has often been a pejorative term. Dissenters have rarely been welcomed and are frequently viewed with suspicion, not only by the dominant power, but also by majoritarian opinion. And yet, in a democracy, dissent is essential. It is indispensable to our freedom. In fact, it is one of the authentic voices of our freedom, particularly in times of exception, in wars, declared and undeclared, when the freedom of the citizen is at stake, and particularly when the state itself seeks to curtail fundamental freedoms in the name of national security or economic development or whatever other perceived end worth pursuing." End quote. The People's National Party feels vindicated by today's ruling of the Constitutional Court, headed by Chief Justice Honorable Brian Sykes, and including their lordships Justice David Batts and Justice Lisa Palmer Hamilton. The court validated the position of the People's National Party that provisions of the National Identification and Registration Act infringe the rights of the Jamaican people, including the right to privacy and access to public services, and deemed the act, the MIDS Act, to be unconstitutional. We will be studying the judgment carefully in its entirety to guide us in considering any future legislation as we seek to secure a national identification system. I want to make it very plain that the People's National Party has always supported and continues to support the need for a national identification system, especially in the context of advanced digital technologies. But such a system cannot be at the expense of the democratic rights of the Jamaican people. A critical aspect of the judgment that needs to be emphasized is that we as a country are ruled by laws, and our Constitution is the supreme law of the country. Good governance requires that government respects the law and the Constitution. You cannot require citizens, no government can require citizens to respect the law while themselves breaking the law or disrespecting the law. This is also a point, I might add, that we have raised in relation to the states of emergency, but now is not the time for that discussion. We made every attempt as an opposition in the House to get the government to stop and think again. We urged them to appoint a joint select committee to consider the legislation. In the end, they resisted every such effort. We told them that legislation of such significance as this required that citizens be given an opportunity to appear before the legislature, to express their views, that specialist associations like the Bar Association, human rights groups and others needed to be consulted directly on legislation like this. In the end, what we were given was bad legislation rushed through the House, and the end result has been a waste of taxpayers' money and a waste of parliamentary time. In fact, when the legislation was brought to the Senate, there were 184 amendments to the legislation, I believe, moved in the Senate. If you want an example of bad legislation, simply look at the number of amendments that were moved in this ad hoc fashion. We would hope that such an approach to the passage of legislation will never be repeated again. I want to point out that many millions of dollars have been spent on it, that even when the legislation was before the courts, the government persisted on spending massively on a public relations campaign, which I might add was contrary to the very spirit of our traditions, that matters before the court ought not to be the subject of public discourse until the matters have been settled by the court. I think what we are having to face over us on the part of the current Jamaica Labour Party government, which is misplaced, which is bad, which is wrong. It is showing disrespect to the rights of citizens. It is showing disrespect to the legislature, and it is showing disrespect to the normal norms of governmental conduct, which have guided successive governments drawn from both sides of the parliament over many, many decades. I believe that the finding of the Chief Justice and the Constitutional Court today vindicates our approach as an opposition and provides a signpost to the government about how it should approach legislation for the future. Thank you very much.
Thank you so much. I must start by commending the legal team who worked so assiduously in putting this matter together. Even while I apologize for the absence of our lead counsel, Mike Hilton, Queen's Counsel, who is presently attending the Commonwealth Law Conference in Zambia. It's almost an overwhelming occasion. We look at this judgment as a victory for democracy. This piece of legislation was the most significant piece of legislation that was enacted in recent times. It not only impacted every single Jamaican, persons who live here for 6 months, but it affected all the citizens who live in the diaspora. So the consequences were serious. We feel validated that the court has shared our concerns. The court has reflected exactly what we have been saying from the outset and has found that this legislation breaches our constitutional rights. What makes me happy today? There are a number of things. One, there are so many persons who had a real interest in the outcome of this case. And I think that once we begin to engage our citizens in their constitutional rights and educate them about it, it can only redound to the benefit of Jamaica in totality. I am happy that our judges have demonstrated their boldness and their courage and their independence from the government. And I am proud that the decision was taken to live stream the decision and that the Chief Justice explained it in language that every single Jamaican could understand. And I can assure you that the response to the outcome has been overwhelming. as a loyal opposition, we are not exultant in the way that things have turned out. We remind the government at this stage that we implore them over and over again to just simply listen to us, as we were acting without malice. We were not acting in a partisan way. We were acting as Jamaicans concerned about the consequences of breaching the constitutional rights of Jamaicans. I have to remind you that it is probably the first time, and Dr. Phillips can correct me if I'm wrong, but we sat in the Senate until 1:20 a.m. Saturday morning. And the reason why we did that was because we could not convince the government that they needed to pause and contemplate what they were doing. And so we had to do the best we could to make a bad job better. Indeed, it was very surprising that the government relied on the very matters that we had fixed, the concerns which we had addressed, to say that it wasn't that bad after all. There is no halfway house when you come to people's rights. And I caution everyone, if you allow those rights to be eroded under the guise of fighting criminality and under the guise of needing to move to a different economy and making money for the country, you are going to find yourself sliding down a slippery slope where before you know it, your government forgets that we voted for them and you are staring at a dictatorship and wondering how you got there. I remind the country of this, because we came under attack. We are backward. We don't like technology.
Bad-minded.
We are bad-minded. And this judgment has vindicated those remarks and has shown that we are simply doing our duty as the opposition. We are the last bastion. We are here to protect the people from the excesses of a bad government.
Okay, thank you. We're on to questions. Just indicate who you are and the media house you represent. Who your question is going to that.
Good afternoon, Dr. Phillips, members of the head table. Liver and Barrett from the Union. Dr. Phillips, I want to get from you your suggestion. What do we do now? Do we start from scratch? Because you have said that you're in support of a national identification system. Do we start from scratch, or do we try to patch this bill together to achieve the objective?
Well, what we really need is to proceed to review the judgment first of all. And then secondly, there needs to be, in line with that judgment, legislation, new legislation prepared, which does not breach the fundamental rights of citizens and which allows for a relevant and meaningful and collaborative approach, which would involve not just the opposition, but all the stakeholders in the society. If that had been done from the beginning, I feel confident that a better piece of legislation which did not violate people's constitutional rights could have been found.
But I want to be clear. So you're saying that before we can get to the point where we think about starting over or patching this together, let's understand and digest the judgment.
Yeah, that shouldn't take you long, just depending on how quickly you read.
309 pages and counting. I just want to remind you that the court has said it's null and void. When they attempted to sever the parts of which we complain, they felt that it just could not work. And indeed, the Chief Justice in his discourse did say that there were even other matters which we had not raised, that when they went through the legislation, they were able to identify. Now, seriously, you can't get much worse than that.
Dr. Phillips, from your experience, what are the implications for the funding that was secured to finance this legislation?
Let me say this. I don't know the specifics of the loan agreement that was signed by the government, or what proportion of it was directed to NIDS itself. Huh? I think that there are many things about preparing adequate databases and so which are not necessarily linked to the piece of legislation. But I can also say that when we were told that the speed of the legislative agenda was based upon the need to secure IDB agreement. We made 2 points. First of all, that nothing could be more important than the constitutional rights of the people of Jamaica, irrespective of what the IDB or any other financial institution felt. And secondly, that those deadlines can be changed. If it's important, we can find the funding. So that I wouldn't link this issue fundamentally to a funding problem.
But forgive me. Even with what you have said, what I want to understand is what are the possible ramifications given the ruling of the courts?
Well, the ramifications is that the monies that you have spent thus far have been wasted. That's the first point. And that therefore the speed, there's the old saying that haste makes waste. And in this instance, you have a classic example of haste wasting the taxpayers' money because it's a loan, it's not a grant. And so that's one aspect of it. The second aspect is that the NIDS legislation itself was just one aspect, as far as I understand, of the overall loan package, and that the other elements could have gone ahead, should they be desirable. The third thing is that let's find the proper way to put a good piece of legislation in place that will enable a rollout of NIDS legislation. Now, I think we need to bear in mind that this issue is not unique to Jamaica. There are a number of countries, India is one that comes to mind, that have been grappling with this problem. We have new digital technologies, and in fact new platforms, communication platforms, so-called social media platforms, which require that society find a balance between citizens' rights and the invasive potential of these new technologies. When you have something as massive as that and with such profound implications, what you need to do is not to treat it as a partisan issue, not to run roughshod over those who raise concerns, but in fact to recognize the gravity of the situation, the seriousness of the issues, and enable the society, all the stakeholders, an opportunity to be able to resolve the issues. And it means also that we have to accept that you won't necessarily resolve all the issues at the same time, and that you can approach it in a sustained fashion to get some buy-in, and over time you move to make it universal. We have had those kinds of issues. If you remember, there was once a time when we were talking about fingerprints to give you the right to vote for the electoral roll. It was a matter of great apprehension in the country. The country got used to it. Huh? And so it's no longer of that kind of significance. Similarly, in relation to criminal justice matters, the taking of DNA samples once was a huge public interest concern. There are lots of doubts. Those doubts have been assuaged. I think that what we really needed to see is a greater degree of respect for people's rights, people's apprehensions and concerns, and a more sober and mature approach to the problems of governance than was displayed by the government. One of the reasons why Parliament has the procedure for a joint select committee. One is meeting now on the abortion question, for example, is because you recognize that from time to time you have legislation of such significance, of such massive public interest concern, that the rest, it can't be just left to parliamentarians alone. That there needs to be an engagement of the general citizenry. We pleaded long before the matter became public. We pleaded with the government to utilize this procedure. And at every point, they resisted the idea. And in the end, they could have done it because from the first time it was raised to the passage of the bill was almost a year. We could have had that kind of opportunity for public debate.
May I just make one observation? You will recall, for example, that one of the things that we said is that we needed a Data Protection Act before we passed NIDS because it involves so much data. The Data Protection Act was sent to a joint select committee. And since Minister Wheatley is no longer the minister, and the Prime Minister was the minister, and now we have a new minister, there has been no attempt to reconvene the Joint Select Committee on Data Protection. So you have to question really what this government, what they stand for, and whether they are sincere in some of the things they do. Here it is, you're collecting data about all the persons in Jamaica, those ordinarily resident and those in the diaspora, and you cannot guarantee how their data is going to be protected, and because of the conduct of a minister, you have not moved ahead with that. By the time we get around to it, it will be outdated.
If I may say, Donna, going into the judgment, and I know this is the judgment here, actually. So for those interested, you're looking at 309 pages and should be very interesting weekend reading. But in paragraph 5, one of the things going on from what Donna said as it relates to the government is that just because somebody is going to cry wolf is not necessarily true. And one of the things that the Attorney General sought to raise in court was that this was naked politics dressed up as a right. So when Julian pleaded that we are looking at rights being violated, the Attorney General says we're not violating any rights. There are no rights to be violated. It's all just politics. And being an effective opposition, which is what the PNP has stood for and stood for throughout, this carried on. Now, if we looked at the Indian judgment, there was approximately 13 civil society groups, and I'm not knocking Jamaican civil society groups at all. Let me make that clear. It's just that when you look at the judgment coming out of India, there were about 13 civil society groups who had joined the claimants. In Jamaica, the People's National Party, being an effective opposition, stood with this because of the significance of it, because of the significance of the rights that were being abrogated. When you see the General Secretary in his personal capacity as the GenSec of the People's National Party, as the MP, step forward, it was a risk. because you have to know that you stand for something and you put yourself on the line. And this vindication coming out, and if I just may read you a short part of it in paragraph 5, what Justice Sykes says was that the learned Attorney General invited the court to dismiss sections of Mr. Robinson's claim on the basis that it was naked politics dressed up in the form of a right. Now, the court went on to say that when you look at what was being said, the Attorney General gave no definition of naked politics, and she did not make it clear whether it was the fact of the politics being naked that made it non-justiciable. And he finished by saying, maybe a bit of clothing may have assisted. So when you get the government trying to knock something down, where they start from is crying wolf, saying it's just about politics. And we see the court saying, no, we're vindicated.
Any other questions? Yes?
Tarisha Williams, TVG. Dr. Phillips, you mentioned that you don't oppose a national identification system entirely. You oppose some certain provisions of the act, and you mentioned some other provisions. But say you should form the next government, would you be pushing for a national identification system?
We would be pushing for a national identification system to be started, to be introduced in a practical way, yes, because we think there are considerable benefits to governance from utilizing the available technologies. There are many areas, electoral administration being one, the delivery of public services, health services, educational services, and others, planning arrangements could benefit from a good national identification system. So yes, we're not opposed, but what we are concerned about is finding this balance. And many societies have started, have abandoned having started, and so I'm not going to diminish the problems or difficulties which might arise. And I would say this, we would be approaching it in a much more consultative and participatory way than has been the case with the present administration.
And you'll remember that most people in this room have a TRN number. I think we, the People's National Party, introduced the TRN. We have it. We have accepted that because it actually makes doing business easier. Moral suasion has its place in the society. If you can demonstrate the benefits of having this national ID card, you don't need to say that if you don't have it, you are going to be fined $100,000 and you are going to be placed before the criminal courts. This is something I feel very strongly about, is that a government must interact with the citizenry to find a way that they can pass on these kinds of benefits without coming down and making it punitive.
You have a question?
Yes, I just wanted.
A comment? Go ahead.
Yeah, just wanted Dr. Phillips to speak more about.
Sorry, can you just say your
Just
name and
name
where you're
and-
Sorry,
from?
Stephen Simmons, Foundation Red News. Just want Dr. Phillips to speak more about the significance of today's ruling, because your party has also called into question, though not in court, the constitutionality of other things that the government has tried to push, like the consistent extension of the state of emergency, and indeed persons have called on your party to challenge it in court. So in light of today's discussion, how significant is that ruling?
Well, let me say that I know you came late, and we mentioned it earlier in our opening, but not to worry. Just to say that the point is that good governance requires an adherence to the law, and the Constitution is the supreme law of the country. and that governments that disregard the law or treat it with impatience run the risk of bringing the whole structure of law into disrepute and not being able to get citizens to buy in and observe the law. So I believe in this area, as well as in the case of state of emergency, where we raise the issue of constitutionality. What this judgment does is to show that despite majority opinion and a lot of noise in the public spaces, there is a valid role for an opposition in our constitutional system to see itself, as we do, as a defender of people's rights and as a defender of the Constitution. As you know, the state of emergency has been challenged in the courts. I think a hearing date has been set for that matter to be considered. A citizen in Montego Bay has brought suit and says their rights were breached, and it is for the courts to hear that. And I think it is important that citizens utilize the courts. And today the court has shown that it has the capacity still for independent action and for bold action. And that gives us at least further courage and hope and expectation that our democratic rights will be protected.
Michael?
Yeah, Michael Sharp, JNN, and we're live. The issue is a political one, sir. How do you assess this in light of the losses? How do you assess this in the scheme of things for the People's National Party? You this morning are on your front foot as opposed to a defensive posture.
Well, look at it this way. When we brought the action, there were many persons who thought it was ill-advised and politically risky. We took the position that all things are not to be subordinated to short-term political considerations, because ultimately we are here to build a sound democracy and a better country which offers opportunities to everyone. So today, our position has been vindicated, and despite the risks, we have been able to feel content that our position was a correct one at the outset. You will have those battles where you win, those battles where there will be setbacks, but we feel absolutely confident that the ultimate objectives which gave rise to the People's National Party are valid, sound, and relevant objectives. And so we go through successes, we go through setbacks, and we continue to move forward to build the kind of Jamaica where every citizen can have their dreams for progress, personal and societal, realized.
No, man. Can't hear you, can't hear you.
Danica Brown, Jamaica Today, just wanted to know.
Jamaica?
Today.
Today.
I have heard the argument that the NIDS was being pushed so aggressively because biometric data is required in terms of the banking system, and that it was necessary to have this data to do certain types of business. Is there any truth to that?
State your question again,
Is
because
there
I
any
haven't heard
truth?
that
Is
the
there any-
biometric data.
Is necessary in the banking to do business with certain countries. Is that the case?
No.
No.
No, not at all. The last one, Liver. Oh, sorry, no, hold on, sorry, go ahead, go ahead.
So I believe it was.
Can you say your name?
Just state your name, man.
I believe it was last Friday that the cabinet approved a 5-year contract to develop software for NIDS at a data center. What do you you believe should be done about that contract? And seeing that the court has ruled in favor of the PNP, what will the PNP be doing now? Are you calling for talks with the government about a new system? What is your next step?
Well, let me say that the government has to take account of the court's finding and determine what way they're going to proceed. They have a number of possibilities available to them. But suffice it to say that that contract for the data processing for NIDS would be affected by such a hearing, and that I would urge the government not to persist in wasting taxpayer resources until they have determined a way forward for the legislation, because too much has already been wasted in this regard.
Last one, Liberty.
Dr. Phillips, let me play devil's advocate here.
Or just the devil.
Not somebody I know very well. The PNP, I'm sure you're aware, is already facing criticisms that once again you're at the forefront of an initiative that emboldens criminals. How do you respond to that?
In relation to NIDS?
In relation to
Emboldens
this?
criminals?
I think the argument is that it provides a way for the security forces to, one, certainly to locate persons in communities, big yard kind of type of communities, and so on and so forth. And as a result, this would enable your crime fighting activities.
We have seen no attempt other than what I would call reckless public relations gimmickry to make that kind of linkage. In fact, there's much that the security forces could do under normal legislation, which, quite frankly, they're not doing. I've noticed they've started to do some things more recently, like identifying people that they want for questioning, like being able to be more aggressive in relation to curfews and cordons in communities. They have still not utilized the full extent of the laws available to them. They have, for the life of me, I can't understand why they refuse, even in St. James and many other communities, to institute further zones of special operations. So to raise a question that needs something which would be down the line in the future is going to be, as far as its implementation, was primarily a crime fighting measure. But frankly, is not a tenable position, and we reject it entirely.
If you will permit.
Yes, please.
It is important that the media look at the act and look at the reasons, the memorandum of objects which set out what it was intended to do. It was intended to identify people and give you a sort of demographic profile. There was never at any point in time a mention of it as possibly being a crime fighting tool. You have to understand that this is one of the ways that they attack the opposition, because they are taking advantage of the people of the country by saying, oh, this is how we fight crime. Same thing as a state of emergency, where they keep on saying that if they don't have a state of emergency, then they can't save lives. NIDS, they said, would give you an identity. We object to that. We as individuals already have an identity. You do not use an identity to fight crime. The police fight crime. Let me remind you that after the state of emergency, one of the things which the Prime Minister and the Minister of National Security and almost everybody in the government said in unison is that 20 known men would have to be released. 20 known men. The Commissioner of Police has said time and time again that they know who the criminals are, but they need more time to build a case. So put that fallacious argument to bed. It is nonsensical, and it must be rebuffed. You do not need an identity card to fight crime. Indeed, I will say this. The Prime Minister himself in Parliament has spoken that these criminals nowadays read The Economist. So you want to tell me they won't come up with a methodology to avoid using a national identification card? We have to get very real about the things that confront us, because that's the only way we can address it.
And we're not suggesting them to log up all people that read The Economist.
All right, final mic.
Yes, if you might help me, sir. I heard from the Chief Justice that the biometrics could involve them knowing what sickness you have and what medicine you take. Were you aware of this before? I mean, I never heard this coming up. Was it a case where the Chief Justice did more deeper research? Hold on for the
GNN what?
Yes.
Which one? This is your own?
This was part of the response that Donna gave, which was that the things we had raised, the court had said, even as they started looking at it, other things surfaced. And this was one of them, because as you may or may not know, the court can, of its own volition, raise issues. So it's not a question of what we have raised and it dies there. It doesn't necessarily occur like that. What has happened is, as the court, and as you may well have known, the hearing was from the 22nd to the 24th of October, and we are just getting the judgment. So the court realistically had up until the 24th of April to have given its judgment. So the court taking 6 months to hand down a 309-page judgment, they've taken the time to review everything in its entirety. Now, as it relates to that, the courts have looked at and you're right, when he made this summary this morning, one of the things the Honorable Judge said was that when you look at the things that can be obtained from an iris scan, it goes far beyond just what the act was intended to do. The mischief of the act is ID. When you start getting iris scans, for example, and palm prints, technology that is still in a very tenuous state, and they are saying that, and when I speak of they, the government is saying that there is the possibility